Today we are going to see about the insurance cover for employees. Today we are seeing to the subject relevant to personal accident coverage, workman compensation and group medi-claim policy. So these are all the three items we are seeing, and what are all the futures and how it can be implemented in the factories. First, comparison between the ESI and the personal accident. In the ESI, minimum number of employees is 10 and the group health insurance is 7. And minimum salary here is 21,000, as you are all aware of that. And there in the group health insurance, there is no specific amount prescribed by the government of India. And the employees contribution here is 0.75, and there is no this one. Sum insured not fixed and no limit in the ESI. Here the employer has to fix the sum insured and decided by the employer. Say for example, if a person is in the position of a GM or director level, the sum insured will be very higher, and those who are in the age group is very lower age, the sum insured will be very less. Like that, the policy modality will change according to the age and the position and other things. That will be decided by the insurance and the respective employer with respect to sum insured. And the caseless claim facility which is available in the ESI, here also the availability is there. And the waiting period 2 years for critical ailment and 2 days for sickness. Here there is no waiting period. Sorry. In the maternity, in the ESI, 26 weeks salary in the case of child and 6 weeks of salary in case of miscarriage. Here also the employer buys a policy with the maternity. It is given both to male and female employees. Male employees can cover their spouse also. In the disabilities benefits, 90% of the pension of the last salary in case of accident that result in permanent disability when the person is in service. In the disability, here in the group insurance there is no such a facility. In the death benefit, family gets a pension in the ESI. Here there is no that facility. In the employer's contribution, here is 3.25 of the employee salary, but there is no this one. The payment we have to made on monthly basis, but in the personal accident policy we have to pay in the year beginning itself. Year beginning or wherever the renewal comes, we have to do that. And the dependents covered by default in the ESI, covered if the employer chooses to add the dependents in the policy of the personal accident policy. Only those people will be covered in that. Before I am going to the next slide, I want to mention about what is the necessity of having the personal accident policy. Earlier, the personal accident policy came for the purpose to cover the entire population in the India for social security. For that purpose, that personal accident policy has come. After 1923, that is Employee Compensation Act has come into the place. In the 1923, the Royal Commissioner of Labour has suggested to bring the policy to cover the employees, those who are working in the factories, to be covered under the insurance. So the employee compensation policy came in the year 1923. After that, the ESI Act has come in the year 1948. So the employee compensation policy has covered little area when comparing the ESI Act. ESI Act is covering end to end actually. But in the Employee Compensation Act, some more exclusion is there, but the ESI doesn't have such exclusions, and it is for the protecting the factory workers and other whoever covered under the ESI Act, they will get the benefit out of it. Even the dependents also get the benefit out of it. We have to see if the person has covered under the personal accident policy as well as in the ESI. We are covering in the both the policies. The ESI rejected the claim, but the employee compensation, he applied for the employee compensation policy. Under that he applied. In that case, the ESI has brought some definitions at here. In the sections 53, the insured person or from any other person, any compensation or damage under the Workmen Compensation Act will not be get into that. Here, under the Baird model, the employee cannot get the compensation from the Workmen Compensation if the employee is covered under the Employee Compensation Policy, that is under section 53. And with respect to I, there must be some connection, nexus between the circumstances under which such injury was sustained by him and his employment or job. In the Workmen Compensation Policy, there are many exclusions has been given. They are not entertaining, even it went to the court and during the time of death and all, they are not extending the benefit. But in the ESI, they are seeing only whether the accident was happened or the incident was happened. There should be some nexus between the incident place and the what he is doing the job. Such injury will be covered under the ESI. And also the personal accident policy also covered those things. That is in the case of New India Insurance Company as well as versus Govindaraj. Coming to section 61, the claiming of compensation for employment injury under the provisions any other enactment other than the ESI Act. Section 61 mentions the enacted laws, while section 53 speaks about particular enacted law, namely Workmen Compensation Act 1923 and also other laws, namely uncodified law, namely common law also. Reading section 53 and 61 of the ESI Act, together we see that they bar claiming of compensation for employment injury not only under enacted laws but also under unenacted, uncodified general law also. Here in the section 61 of the ESI Act, what it says, if the employee could not get the compensation from the ESI Act, he can also get the Workmen Compensation Act, but if he approaches under the ESI Act, he should get the benefit from the ESI Act only. If the ESI is not allowing that one, we can get the benefit from the Workmen Compensation Policy. So both the laws are benefit for the employees. Then relevant case laws in this, it was held in Tracon versus Associated Electric Agency and others, that the legal heiress would not be entitled to get the compensation under the 1923 of the Act as he was insured person. And the aforesaid authority makes it eminent clear that once the employee is insured person under section 214 of the 1948 ESI Act, neither he or nor his dependents would be entitled to get the compensation or damages from the employer under the 1923, that is Employee Compensation Act only, not under the Employee State Insurance Act. So this is the another thing. In the case of managing director and others versus Devi Lal and others, in this case, view that mere negligence on the part of workman, which may have resulted in the accident, doesn't not take away the case from the purview of the employer liability to pay the compensation if he has suffered injuries in the accident arising out of in the course of employment. Here, the employee can be, he is not under the accident was happened at the working spot. He would have went away after finishing the shift hours. While he is walking towards his house, or he is going by bicycle, or when he is reaching to the company provided quarters, that is also come under the purview of in the course of employment. Actually, in many of the Employee Compensation Act, it says that that is also arising in the course of out of employment. That is the definition given in the Baird model. Then, the D distinguish between the ESI Act and the Employee Compensation Act. What is the difference? Workmen Compensation Act is mainly, it focuses those who are not covered under the ESI Act. Here the ESI Act covers entire factory workers, so it covers the entire population in the respective factory. That is the main thing which is available in the ESI Act. ESI Act intention of the legislature would not have been create another remedy and a forum for claiming compensation for injury received by the employee by accident arising out of and in the course of employment. So, the ESI Act is very much enhanced and it covers all the injuries which is happening in the course of as well as in the out of employment. Now, we are coming to Employee Compensation Act futures and all. The employee compensation is compensated when the time of disabilities, loss of income. If a person is couldn't able to come to the office because of accident, he can claim the wage from the insurance company which is available under the WC policy, provide the injured staff with a sufficient medical treatment to reduce the work related miscarriage, to reduce the lawsuit pending in the court. Here, we need not to wait to the pronouncement of the court. We can approach the insurance company and get the benefit out of it. In the recent case, is Palanivel versus Deputy Commissioner of Labour, the Madras High Court held that employees with wage exceeding the wage ceiling limit as per the Employee State Insurance Act are not eligible to the Employee State Insurance Act. Such employees are entitled to claim under the compensation under the Employee Compensation Act. Here the ESI is very clear. If the employee is out of the ambit of ESI Act, they should be covered under the either through the Employee Compensation Act or under the Personal Accident Policy that is enumerated in the recent court judgment, that is in the S. Palanivel versus Deputy Commissioner of Labour in the Madras High Court actually. An employee is defined under the 2 subclass Employee State Insurance Act. Any other than person who is employed casually and has been employed for the purpose of employer business. Whoever coming and going on every day and he is not covered under the employee definition of the Factories Act as well as the ESI Act, they are not comes under the Employee Compensation Act. So, whoever works for the company regularly, they are on the muster roll of the company, they can be enrolled into the Employee Compensation Act. Other people will be covered under the Personal Accident Policy or some other policies. And here we have to see about, there are 3 doctrines are available. One is doctrine of negligence, another one is doctrine of notional extension and another one is doctrine of peril. The doctrine of notional extension is when the person is working in a factory, he doesn't aware of what is the endanger in front of him and he went away and he is doing the job and something happened to him, that will come under the doctrine of notional extension. Say for example, if a person is working in a company, he is going out of the company and going in the transport provided by the company. When he is traveling in the transport, he met with an accident by mistake by another vehicle hit in the bus and the employee died and he can get compensation under the doctrine of notional extension. So, in the course of out of employment will apply here, that is under the doctrine of notional extension. And the doctrine of negligence, normally under the Indian Penal Code provisions also as well as in the Factories Act also and the ESI Act also, the negligence could not be entertained because the unsafe condition and unsafe action should be controlled by the employer. But here the Employee Compensation Act, the doctrine of negligence will also be entertained and the employee get the compensation. If the employee is allowed, even though the employer could not able to see, say for example, some wires insulation could not be done in the factory and the employee touched the wire and he has been electrocuted. So, at that time also he can get the compensation, even in his death, the deceased could get the benefit out of it. That is called the doctrine of negligence. And the doctrine of added peril, when an employee performs a work which is not required to be done by him and it is found to be hazard, then the employer is not able to pay the compensation. So, if some employees are handling some hazardous chemicals or something like that, he knows that, the employer knows that the hazardous chemicals will harm to the employees, even though he is engaging, that will come under the doctrine of peril. So, here the Employee Compensation Act will reimburse the amount when the time of injuries, permanent disablement and partial disablement as well as for the death cases. And when the employer not responsible under the employee compensation policy, when the employer is not liable to pay the compensation, employee is not liable compensation for lesser than 3 days of the incident, there is no problem for the victim. In those cases, the WC will not, the employer will not be get into the issue. Accident causing injury which does not result in the death or permanent total disability, and due to the following cases: intoxication, the workman consumed some alcohol or narcotic items that causes for accident, the employee will not get the benefit, and the employer will also not responsible for that. And the disobedience of the safety rules initiated by the company, if the employee is not following those things, that will also, the employer is not responsible. And the removal of safety guards, if the normally all the machines are safeguarded by the employer while buying the inbuilt safety system is there, but the employee for his convenience he is removing the things. On those cases also the employee compensation cannot be entertained, and the employer is not responsible for the claim. Here we are going to see about the case studies. In the case of Lancaster and Yokeser versus Railway versus Hiley, what is the part of injured person? Employment to hazard, to suffer, or to do that which causes his injury. There are three things to be taken into consideration while we are going for a WC claim. Under the case judgment has given in the case of Lancaster and Yokeser Railway Company versus Hiley. Was it the cause of the insured person employment to hazard, to suffer, or to do that which caused his injury? If yes means the accident arose out of employment. So here the employment injury should be caused because of employment hazard. Then the employer is responsible to protect those workmen. Next, was one of the ordinary risk of employment or reasonably incidental to employment, or conversely was an added peril and outside the sphere of employment. The peril is there, and also the outside sphere of the employment also will be covered under the WC policy. As per the court judgment given in the Lancaster and Yokeser Railway Company versus Hiley. This is the famous case under the employment compensation policy. And the workman should have acted as he was acting, or should have been in the position in which he was, whereby in the course of employment he is assigned the injury. So the employment injury should be mentioned, and the employment injury is to be proved to get the employee compensation policy. And when in the case of Oriental Fire and the General Insurance Company Limited versus Sundarbai Ramji in the Gujarat High Court, it determines the accident arising out of the employment. When the deceased labor was doing a work involved in the hard labor and the stringent physical exertion, after 3 hours of work he was having the chest pain and subsequently fainted. The commissioner asked the insurance company to give the money to the deceased, but the insurance company declined, stating that the employee is already having the pre-existing disease, so we couldn't be able to entertain this claim under this case. But the court said that the personal injury resulting into the death has direct and proximate nexus with the employment. Because of he is doing the job, he met with an accident and he died, so we have to give the compensation to the victim. That is in the case of Oriental Fire versus General Insurance Company Limited versus Sundarbai Ramji in this case. And in the case of Best Undertaking Bombay versus Mrs. Angie, a public transport service run by the Bombay Municipal Corporation, owned by a number of buses and employed a staff including bus driver for conducting this such service. The deceased driver finishes his work for the day. After leaving the bus in the depot, he boarded in some other vehicle. While he is going in the lorry, he met with an accident. The deceased made a claim, but the insurance company denied the claim because it is not arising in the course of employment. That was the stand taken by the insurance company. But the Supreme Court said that when the employee, after finishing his job, he is not yet reached the home, during the course of employment, if he met with an accident and he died means that will come under the arising in the course out of employment. That was the Supreme Court verdict in the case of Best Undertaking Bombay versus Agents. And now we are going to see about the futures in the group medi-claim policy. I hope all the companies are having this one, and here there is no pre-medical checkup. If I am joining in a company, I don't want to go into the pre-medical examinations and all. But in factories, normally we are doing pre-employment examination that is stipulated under the Factories Act as well as Medi-Claim Act, and that's why they are excluding this one. And if someone having the claim after joining the company and he is having some inherent diseases, so if he made a claim means that is rejected by the court. We are going to see the case laws in the later stage, and the premium is also lower. If we are going to take the individual group medi-claim policy, the premium is very high, but when we are going for the cluster group medi-claim policy, the premium is very less, and there are some waiting period for each diseases, for maternity, for everything in the individual policy. Here in the group medi-claim policy, there is no waiting period, and the coverage against the pre-existing diseases in the individual policy, we have some limitations are there. Here there is no that one, and the top up is also available. If a person is sum insured is 3 lakhs, when we have a buffer amount in the for the corporate, we used to take, say for example, for my position it is only 5 lakhs means normally the corporates will put some amount of money as a buffer for the corporate of 5 lakhs or 10 lakhs like that. If I exceeded 5 lakhs means, if my medical exemptions are exceeded 5 lakhs means I can take from the buffer amount that is available in the group medi-claim policy, and a tax exemption is available for the employer. In the case of Nanda, he went to the abroad. Before that he took the medi-claim policy, and after reaching the US he went to the hospital and he did the angioplast, and he made a claim under the medi-claim policy, but the court the insurance company declined the payment, and he went to the NCRTRC, and they concluded that since the complainant had understanding stand-in medication which was not disclosed while buying the medi-claim policy, he failed to comply with his duty to make complete disclosure of his health condition. So when we are joining in a company also, we have to disclose what are all the diseases we are having in our body, or else we could not get the claim under the group medi-claim policy. That is a very famous case in the Nanda versus this one. And there are some of the list of items which are available in the group medi-claim policy, may cover domiciliary expenses. Some of the policies will have the domiciliary expenses. Less than 24 hours hospitalization, normally all the insurance companies are not entertaining those things, and some of the insurance companies are excluding this one dental area, that is comes under the aesthetic things and all. So they are not entertaining those diseases and all. And we have seen many of the cases which are in the corona period, they are not entertained, and they asked to take the separate insurance for COVID things and all after the direction of MHA. So these are the present pathologic condition of India. And exclusions. A group health insurance policy may offer limited coverage owing to supplements, and the employee therefore may not be fully covered. And the master policy offered by companies cover all the employees in that organizations under the same umbrella, and therefore lacks of customization. So say for example, my age is around 50 or 60, I have to customize my insurance cover and all, but the company may have sum insured, from the sum insured till the time of extension of medical benefit and all, that will come under the cluster policy. So there is the exclusions are there in the group medi-claim policy. The policy is valid for a certain period during which the employee is working in a company. The company will extend the policy till we are in the job. Otherwise, we have to get the another our individual policy. That is a export facility is there. When we are leaving the company, we can export the things from our group medi-claim policy to our individual policy till joining in any other employment or something like that. That is available under the group medi-claim policy. And companies may reduce the health insurance cover at their discretion or increase the amount, and the employee and his family are not covered in case of any interval between the job, and the policy may become invalid if the company doesn't pay the required premium or the insurance back out of the contract of the company. Many companies are may not provide the health cover to the employee's parents, and employee's parents are also covered till the 80% of the sum insured. Like that, many restrictions are there. But in my experience, some of the government-owned companies, insurance companies are doing better. In my experience, the employees coverage under the group medi-claim policy. The minimum number of employees in the company should be 20. The age range of the employees should be between 18 to 70. And the entities who are not eligible for group health insurance plans are family business and sole entrepreneurs. Then we are going to see about what is the difference between the ESI and the personal accident policy. Sorry. The list of network hospital in the comparatively very high in the personal accident when we are taking the personal accident policy, but in the ESI it is very rare, and the death benefit. The coverage of ESI is 90% of the lost on salary in case of permanent disability of the death of an employee. But in the contract, group health insurance doesn't give any pension to the employee's family. And a critical illness, the ESI is, however, treatment of the critical illness is covered if the employee is covered under the contribution period of 2 years. So critical illness will be extended by the ESI, but here there is no such a thing. Maternity benefit also, everybody knows that now the government of India has extended the maternity benefits for the women employees. And the loss of job, the ESI is extending 24 months for the unemployment allowance and all they are giving, but in the personal accident policy there is no such a thing. And these are all the pros and cons in the group medi-claim policy. Free coverage because company is paying, no waiting period. Cover for family members also in the group medi-claim. Maternity and newborn baby coverage is there. Cashless benefit when we go to with the card, when we approach the hospitals, tied up hospital, they will extend the medical facility, and OPD coverage is, outpatient coverage is also there. Preventive health care and extra benefits are under the group medi-claim policy. And the fear of discontinuation is there. That is a fear under the group medi-claim policy. Employer dependent cover is restricted, lack of control and inadequate coverage. These are all the some of the cons is also there. And the employee is not getting any tax benefit when it is coming under the group medi-claim policy. Some of the claims are disallowed under the group medi-claim policy. That is one fear is there. Many of the insurance companies are disallowing the expenses. Say for example, 1% of the sum insured is covered for the group medi-claim policy. Like that, there are some restrictions are there. Now the IRDA is coming out with some of the restrictions imposed with all the insurance company. They have to extend the benefit. During the COVID period also, IRDA has given so many directions to the insurance companies. And unreliable for personal finance and the planning, that is also there. So these are all the some of the things which are I want to present during the today's session.